Hi, this is Lotus Academy and I am going to talk about Bankruptcy Bill. India has moved a step closer to a new bankruptcy bill after the law has been passed from Lok Sabha on 5th May 2016. Now, the bill is going on the bench of Rajya Sabha. Once it has been approved by Rajya Sabha, the law will ensure a time-bound settlement of bankruptcy and it will transfer to the President's bench. Once it has been passed by all the benches, then it will become the law for Indian Constitution. The creation of the law this law will basically improve the World Bank's doing business ranking as well. The bankruptcy, basically, now we would have to understand why are we discussing bankruptcy bill. What is bankruptcy bill? There are few other questions which should be arise in our mind, that why do we need bankruptcy bill? And how can this will end? Why our Indian government, why our politicians are discussing in this law from Lok Sabha and it has been transferred to Rajya Sabha as well? Why it is that much important? So, first of all, we will focus on what is bankruptcy. In this, bankruptcy is the legal status of a person or other entity that cannot repay the debts it owes to creditors. In some countries, including the United Kingdom, bankruptcy is limited to individuals, and the other forms of insolvency proceedings are applied to companies such as liquidation or administration. Basically, the term bankruptcy means broken bank, and it's a white-collar crime. Now we have to focus on why do we need bankruptcy bill. Basically, the failure of the business impacts employers, shareholders, lenders, and the broader country's economy. In a country like India, particularly because of delays in making decisions on the viability of business, tactics employed to sell off the assets, changes of management, or litigation that goes on and on. The drag on new business units, jobs, income generation, and economic growth can be significant. Although India does have some laws, including one on securitization and enforcement of security, and other mechanisms like corporate debt restructuring, that is CDR, that address to the problem of the insolvency of firms. But the matter of the fact is that these laws have not worked because of inefficient enforcement and court delays. Few examples like JP Group and Malas are the few examples of bankruptcy which shows the bankrupt and affects both the employers as well as the banks. Due to this, NPA, that is non-profitable assets, increases, which affects the economy on a broader level. Further, we will talk about the laws of bankruptcy bill in other countries like in Argentina. Laws of bankruptcy bill in other countries. Since it is that much important that there are many countries which have been applied this bankruptcy bill for many years, like in Argentina, the National Act 24.522 de Concurrency Quebras that regulates the bankruptcy and the reorganization of the individuals and companies, that public entities are not included. While in Australia, the Bankruptcy Act 1966 that is a legal system that governs the bankruptcy in Australia. Only individuals can become a bankrupt. In companies administrating health code plans, equity companies, and few other local entities. It does not have to run in the state-run companies. While in Canada, it is applicable to businessmen and individuals. The Office of the Superintendent of Bankruptcy, a federal agency, is responsible for overseeing the bankruptcies are administered in it is a fair and orderly manner by all licensed trustees in Canada. When it comes to China, the People's Republic of China legalized bankruptcy in 1986 and it has been revised in 2007 again. In Ireland, bankruptcy in Ireland applies only to natural persons other than insolvent processes, including liquidation, and examinerships are used to deal with corporate insolvency. While in India, till now, India does not have a clear law on corporate bankruptcy. That's quite shocking. Yes, we do not have a clear law on corporate bankruptcy. The individual bankruptcy, though we have individual bankruptcy laws which have been in existence since 1874. The legal definitions of the terms bankruptcy, insolvency, liquidation, and dissolution are contested in the Indian legal system. There is no regulation or a legal body upon bankruptcy which denotes a condition or an inability to meet a demand of a creditor, as is common in many other jurisdictions. Now the question is how? How it will help How can a bankruptcy bill help? It will help firms to be either restructured or sold off with the limited pain for all involved. See, in some cases, if this done swiftly, assets can be put to good use and the firm can be revived. Delaying a decision on whether shutting of a firm or trying to use the firm and the firm can be revived. Delays a decision on whether to shut up the firm or to try to revive it causes destruction of values for all the involved. For banks or lenders, the money recovered can be lent again, promoting efficient allocation of resources. Besides, development of financial markets such as bond market with clarity or repayment for debtors. Now the question is, what is India planning? Since we know what is bankruptcy, why do we need it, how can it will help, now what is our country planning? Since till now we don't have a clear law for bankruptcy bill. See, there was a committee headed by a former law secretary, Mr. T.K. Vishwanathan, has suggested a timeline of 180 days and it is extendable by 80 days to deal with the applicants for resolving the cases of bankruptcy. During this period, the management of the distressed firm could be placed in the hands of resolution professionals, a new class of professionals which will be equipped for the bankruptcy cases, for such kind of cases, and it will be supervised with the new regulator. The National Company Law Tribunal will be adjudicating authority with jurisdiction over companies with limited liability. So the law will have to be approved by the Parliament. It is mandatory actually. So now we know the bankruptcy bill and the aim. The aim for the bankruptcy bill is to either close a firm that can't be revived or change their management to protect the investors or depositors. Because it is very, very important, because the failure of large banks or institutions imposes cost on taxpayers in the form of bailouts or capital infusion. The proposal is to promote the Deposit Insurance and Credit Guarantee Corporation, that is DICGC, as a resolution corporation. Thank you.